Protecting children. Rebutting joint custody in high-conflict child custody in Oklahoma. Rebutting joint custody in a child custody case is a burden of proof that the person disagreeing with joint custody must meet. Oklahoma law increasingly encourages meaningful involvement from both parents. In many cases, courts begin with the idea that substantial shared parenting time, often described as 50-50, serves a child's best interests. However, equal time is not automatic. In Oklahoma, the presumption in favor of joint or shared custody can be rebutted when clear evidence shows that equal parenting time would place the child at risk. The 50-50 starting point, not a guarantee. Modern Oklahoma custody law promotes frequent and continuing contact with both parents when appropriate. Judges often begin by considering whether joint custody or equal parenting time is workable. But a starting point is not a mandate. The governing standard remains the best interests of the child under Title 43. If credible evidence shows that equal time would expose a child to instability, danger, or emotional harm, courts have the authority to award primary or sole custody. The presumption yields to proof. 2. The 2026 fitness factors courts are examining. Recent developments reflect heightened attention to three recurring issues in high-conflict custody litigation. Substance abuse remains one of the clearest factors undermining parental fitness. Courts examine patterns of alcohol or drug misuse, treatment compliance, relapse history, and its impact on parenting capacity. Isolated past mistakes may not control, but ongoing instability often does. Domestic violence continues to weigh heavily in custody determinations. Oklahoma law directs courts to consider evidence of abuse between parents and exposure of the child to violence. Protective orders, criminal charges, and documented incidents can significantly influence the outcome. Coercive control is receiving increasing judicial recognition. This includes patterns of intimidation, isolation, surveillance, financial control, or manipulation that create an atmosphere of fear or dominance. Non-physical, coercive control can undermine a child's emotional safety and disrupt healthy development. Courts are moving beyond visible injury to assess patterns of power and control within the family dynamic. High conflict versus unfitness. Not all conflict defeats shared custody. Judges distinguish between mutual hostility and a demonstrable risk to the child. High-conflict co-parenting alone does not automatically eliminate 50-50 arrangements. However, when conflict crosses into intimidation, substance-driven instability, or emotional harm, the analysis changes. The question is not whether parents dislike each other. It is whether equal time endangers the child's welfare. Clear and convincing evidence. What courts look for. To overcome a shared custody presumption, the parent seeking primary custody must present strong, credible evidence. While every case is fact-specific, courts often look for documentation such as verified criminal records or protective orders, failed or refused drug and alcohol testing, treatment noncompliance or relapse history, medical, therapy, or school reports documenting emotional distress, witness testimony from neutral third parties, recorded communications showing threats or coercion, or evidence of repeated parenting time interference rooted in control rather than logistics. Courts examine patterns over time. Isolated accusations are rarely sufficient. Consistency, corroboration, and professional documentation carry significant weight. The burden is substantial, but not insurmountable. The role of expert evaluations. Mental health professionals and custody evaluators often play a central role in rebutting 50-50 arrangements. Structured evaluations can identify coercive control dynamics, substance dependency patterns, and emotional harm to the child. Judges frequently rely on expert findings to translate behavioral patterns into measurable concerns. Professional evaluations can bridge the gap between allegation and proof. Sole custody as a protective measure. When courts determine that equal parenting time would place a child at risk, they may award primary or sole custody to one parent. The other parent may receive limited or supervised visitation, mandatory treatment requirements, or structured conditions for future modification. Sole custody is not a punishment, it is a protective measure designed to ensure stability and safety. Addressing fear surrounding 50-50 laws. Many parents fear that evolving shared parenting trends automatically override safety concerns. That fear is understandable, but misplaced. Oklahoma law does not force equal custody in the face of credible danger. The statutory framework still prioritizes child safety above parental equality. The presumption of shared parenting exists only when both parents are fit and able to provide a stable environment. Child safety is a great tool that exists for rebutting joint custody. When fitness concerns are proven, the presumption falls away. Tulsa child custody attorneys. In Oklahoma custody cases, shared parenting and 50-50 arrangements are common starting points, but they are not automatic outcomes. Rebutting joint custody is a burden of proof that can be met in certain circumstances. Substance abuse, domestic violence, and coercive control remain powerful factors that can rebut any presumption of equal custody. For a free and meaningful consultation with a child custody attorney at Kania Law Office, call 918-743-2233.